Honorable Attorney General, good afternoon and thank you for the opportunity. Members of the panel, members of the public, I am going to start this evening by trying to be even shorter than the Commissioner of Police. At least if I could achieve that, I will be satisfied this afternoon. But if I was to compare this afternoon session to that recent T20 match, I think that everyone would agree that that the Honorable Attorney General produced an innings worthy of Chris Gayle, and all the speakers have made substantial innings. I just hope you're not expecting a Braffett type performance from me, because I don't know if I could live up to that. The beauty about coming last in terms of the presentation is that everything that really that has come before is really what I wanted to say. And I think I just want to underscore a few points that really I think needs to be said. And the first point is, and it's been said eloquently by all, but there's something about Mr. Israel Khan and how he puts it over. We're tired of the talk. We're really tired of the talk. I think I've been practicing not as long as many of these eminent persons, but I've been doing this almost 20 years, and I can't tell you how many occasions I have heard recommendations, how many committees I've been on, how many occasions we've come up with ideas. And just for the Attorney General's benefit, the Law Association, and I had the privilege of being on it, I can't remember how many years ago, but I remember that we had done some 60 recommendations on criminal justice. But it's so many years ago, I guess it falls into the pot like everything else. There's been the Crime and Justice Commission, there's been so much. But the time for talk is over. Everyone has said that to us. We're really at a level of frustration now. And that level of frustration that we have is not only those of us who practice in the criminal justice system. The Attorney General said, I have sat as a judge in Trinidad, and I've had to deal with cases. I've had to sit in the Eastern Caribbean and compare Trinidad to Grenada and see in Grenada, with the resources they have, or more likely don't have, a murder trial is done in 4 years. And you wonder, well, what's really going on here? And then one of the most frustrating experiences I have had, certainly on my time on the bench, was one day in the Port of Spain exercise. A gentleman came up in front of me, charged with very serious crimes, and he had been locked up for about 10 years, and he wanted to start his trial. And I was in the middle of a trial. I was doing a trial, so I could not start his trial. And I always remember, the man stood up in the dock, and he said, I'm not leaving here today. Right? I'm not leaving. The police have to come and take him out. Now, this was not a man who was being deliberately and willfully disobeying the court. This was a man who was frustrated. He pulled out a picture of his 2 children. And the hardest thing is to stand up as a judicial officer and to tell this man, well, I cannot deal with your case. And that was the reality, because everything always has to line up for you to be able to start someone's case. And what I wanted to do this afternoon in my no more than 15 minutes was to try to put across to you some of the practical difficulties that really takes place. We seem to know all the solutions. We seem to have all the recommendations. But I just have a sense that on the ground, no one is realizing the problems on the ground. And it's one thing for people to be frustrated and to come before you, or even when you represent me, because now I'm no longer a judge, I practice in the criminal court. And I want to give you some practical examples of things in the last 2-3 months that I've been facing, okay? And it's going to explain to you what we're working with. Now, I don't want for a minute to give the impression that trying to solve the limitations within the criminal justice system is anything but a Herculean task. It's amazing. It's a mountain to climb. And the truth is that I have a great degree of sympathy for the institutional heads who have to deal with the problems, whether it be judiciary, the prisons, the police, admin, even the government. I certainly think people are trying their best. But that having been said, I wish to make some suggestions, and this afternoon, which I hope at face value can make a difference in how the criminal justice system works. And as a consequence, could have what we call a trickle-down effect. A trickle-down effect so that it will make a difference in the lives of people on remand. Now, the first one has to be the most obvious. We must aggressively come up with an action plan that will fast-track trials of persons in custody. Included in this would be the need to abolish preliminary inquiry. The Criminal Bar Association supports the abolition of preliminary inquiries. Again, it just simply doesn't make sense. Why are you charging people 2 sets of money to come to get representation in a PI for a magistrate to say, yes, there is some evidence, and then send it up? And then you have to send that, all them papers after you do a magistrate court hearing to the DPP, who then has to determine an indictment. And let me tell you what my experience is. My experience is that when I'm doing a murder case right now in the Tunapuna court. The young man who's charged for murder worked with a company and was a security officer. He's parked up on the highway, 5 o'clock in the morning, a vehicle comes up and a person approaches them in an aggressive manner. He gets scared, he pulls out, the person has a cutlass, he pulls out a gun, comes out the vehicle, and in that circumstance, the other person trying to get away, he shoots and the person dies. He's charged for murder. There's a proper basis for laying the charge. But it's a kind of case where it is a question of whether it was acting out of self-defense and whether he was reasonable in how he acted. What is my position to explain to his wife and his 2 children that how, yes, I understand that your husband, has something to say that he didn't do that deliberately, wasn't intentionally, but you're not going to get, nobody going to hear you until 12 to 13 years down the line when you get in front of a jury, and then the jury go hear you and say, yes, you know what, we think you are acting out of self-defense. What happened to your 13 years of your life and your children and your wife and your family? And that is a human aspect. And I'll tell you, these are the real practical issues I have to deal with. You go to court, the lawyer comes ready, we're ready to start the case. But you have to get, in some cases, a DPP officer assigned. That takes months. That means the file has to go through the police service up and then to the DPP's office, which takes months, okay? You then start asking, well, what options? Can we have what is called a paper committal? Let's fast-track the program. Now, paper committals were brought in, and this is one of the points I want to make to the Attorney General. We pass too much legislation. We bring in too many things that the administrative infrastructure is not there for. I'm going to give you an example. Paper committals were brought in quite a few years ago. I remember when it first came out, I was representing a young lady, pregnant lady, charged for murder of her brother. Very poor people who came from Matlot side. And there was a fight over a plate of food. Okay, there was a fight over a plate of food. Sister killed brother in a situation where it just got out of hand. Okay? You go to court, and I was asked to come and help the family. It took me 2 years to get the prosecution to be able to get the papers ready, to even begin to start to hear the evidence. 2 years. Now, in that case, I was able to persuade the magistrate that it should have been manslaughter, and so I got her bail after 2 years. All right? Somehow I don't think that case has even been listed in the High Court yet. All right? Now, you take other examples. Because we pass all these pieces of legislation, because we implement all sorts of things, the audio digital recording system, which was supposed to be, landmark reform with a view to save time so magistrates don't have to write notes. And you could just do that. You do a trial. I always remember the Marshall Montano trial. And everybody talked about how long it took. But people didn't realize that what was happening, we did it under the audio digital system, and it was recorded. But when time came to get the notes so that we could prepare submissions. It took a year and a half because it didn't have transcriptionists to type up the audio. So, you ask, why is it the things take so long? But it's the infrastructure. You pass all these grand pieces of legislation. And, I'm happy that the Attorney General says we have things in place. But the lesson, the experience of those of us who practice is we pass it and we don't fund it and we don't put the infrastructure in, and what we're left with is going into the courtroom trying to get it to work. I mean, that's why I come to these recommendations, because at the end of the day, a lot of it is talk, a lot of it is well-intentioned, but when things are put in place and the infrastructure is not there, it's useless. Whether you multiply 2 by 0 or 100 by 0, you're still going to get there's going to be no improvement at all. So, abolish the preliminary inquiries, equip the judiciary with the appropriate resources and infrastructure. Now, I say that tongue-in-cheek because I get the impression that large, ridiculous amounts of money are being allocated. But are we seeing it translating into efficiency? And my answer is simply no. One, Mr. Khanna says he thinks the system is on the verge of collapse. Mr. Rajkumar thinks it has collapsed. I remember a judge of the Court of Appeal many years ago when he retired off the bench, lamenting that the system had collapsed. That was about 8 or 10 years ago. We have to really call a spade a spade. Is the system working? And you could throw as much statistics as you want. The reality of the person on the ground is this thing ain't working at all. And that is what we have to deal with. I cannot understand. We did it when they changed what we call in the civil courts. We changed from the old rules to the new rules. They brought in judges, we brought in retired judges, and we did temporary courts, and we cleared out the backlog. Why we can't do that in criminal? Why is it that we feel we have to build a building? In Grenada, there's something called the Juris Project, and they brought in extra judges, and they improvised space, and they set up the courts, and they're working. What is preventing us from just getting some judges, temporary judges, and we just start clearing out? Let us make a priority the persons on remand who cannot get bail. Because you know what the reality is? We've passed legislation. What we did was we started to implement a system in relation to bail where we started to say, if you have 3 strikes, no bail. Now, that makes sense. I could understand you saying, well, okay, if you keep getting in trouble time and time, it makes sense not to grant you bail. But you balance that next to the fact that we are giving you no trial. So then what is the point? Because the whole system of the way the criminal justice system is, you hold you, they arrest you, they charge you. But they're supposed to go and get a hearing to determine if you're innocent or guilty. If you're guilty, you do the time. But if you're taking 12 years to find out you're guilty, I remember cases that I have been involved in where people spend more time waiting on the trial than the sentence. And they had to sue the state, and they got hundreds of thousands of dollars in compensation. Where is the justice? I always remember this case sitting as a judge in San Fernando. Fella charged with a joint of marijuana. For some reason, I don't know how he fell through the cracks in the system, and he had his matter referred to the High Court. Nobody recommended summary trial. 6 years he stayed in the prison, and he came up before me while sitting in San Fernando, and I had to give him a bond and release him. All right? I remember, that was in 2009. I'll try and remember the name. But you have these situations that people fall through the cracks, which raises the question, do we have an appropriate system of monitoring? Because I'll tell you, many of those cases is prison officers who call me to ask me to help people. It's the prison officers who go out of their way to say, look, they have this fella there, we just find it not working, and it is the prison officers who is come and ask people, members of the bar, see if you could help this person. And we need more of that. Now, as an absolute priority, resourcing key institutions forensic science center, you send marijuana, you send a gun to be checked 2 years, 2.5, 3 years, and magistrates don't want to start the trial. I had a case in Princestown yesterday, it came up. Recently charged, I have said to the court, we're not disputing that the items found is marijuana and cocaine. We're not disputing. So we don't know it. Because there's a deficiency in the legislation, you can't do admissions in preliminary inquiries. So in other words, they passed laws some years ago to speed it up by saying, not everything you need to call a witness for. You could get the defense and the prosecution to agree, we agree on this. Instead of saying that somebody dead and they see him and they went to the funeral, you don't need to call that witness. But now, because they passed those reforms at a time when nobody thought preliminary inquiries would be around, and preliminary inquiries still here, I can't even use that to speed up the case. And those kind of things could save 8 or 10 witnesses off a case. You know, the way we approach these things. So we need to understand the deficiencies in the system. So Attorney General, that's something I think needs to be looked at, the question of admissions and preliminary inquiries. The police service, I have so much sympathy for you all, but there is a great demand created and placed on court and process and the administrative support to be able to get statements prepared and sworn to, etc. And I just don't get the sense that the police service has gotten the support they need. I see the will, but again, last week, a young lady charged of causing death by dangerous driving on the priority bus route. She knocked down somebody by Mount Hope there. Charged in 2012. We started the case. We took one witness. For the last 4 years, I have been begging, could we get statements so we don't have to call every witness in this case? There are 9 witnesses in the case. There's no eyewitness. 8 of the witnesses are formal witnesses. So I don't really have any dispute with it. Could we have statements so we could just read it in and get on with it? It's taken 4 years and I can't get a statement, a paper committal. The magistrate looks at the DPP officer. The DPP officer, I have tried with the complainant to get these things done. It hasn't been done. So in other words, you just get the sense that you pass in law, you put in all sorts of things in to speed up the process, but the real truth is it not coming to fruition, it not working the way it should. And, you know, I mean, in a special category, the DPP's office, I have only the highest respect for the Director of Public Prosecutions. I don't know if I could handle his job. But if you tell me that 99 vacancies in your office out of 149, you expect any sort of justice in the courts? And I mean, having sat as a judge, you are faced with a situation where a prosecutor comes before you, a lawyer, a defense lawyer comes, they want to start the case, but of course, the prosecutor can only do one case at a time. The list has so many other cases. Everybody else coming, they want their case started. But you know what the reality of it is? Because it's one prosecutor per court, that prosecutor can only do so much in 24 hours in a day. And when, you know, as a judge, we like to come and say, are you all ready? And they say yes. You know, we come to understand something. Ready mean where we're ready to start. But ready don't mean we talk with witnesses, or we check, or we read the file, etc. Because they're so overburdened that although their intention is, they have the best intention in the world, they have to do it on a day-by-day basis. The DPP's office needs to be staffed so that they can get help, so that when a judge says, are you all ready? They are ready, and we don't have in the middle of the trial, well, I need to find this witness, or I need to do this, or I have to make this application. Because we're going to put in case management rules. And that's the best thing I can think of to help the process. But those case management rules are not going to work if the DPP's office is in such a state that there's one officer who's dealing with one court, who have 20 or 30 cases, and who finish a trial today and have to start a next trial. When he or she get in time to properly read the file and to prepare. And it's not that people lazy, it's that the realities of the system That's what we're dealing with. Now, the question of reform of the bail system is something very close to my heart. Because if you're poor in this country, you're getting bail. And you know, how many people can really say they have property that not mortgage? I mean, I don't know how much you can say that property. Then how much is a smaller category of property that not mortgage? And then this whole thing about the illegal bailer system where you pay some money, 10%, it's illegal. But people have no choice. They have their loved ones who they have to get out. And that is a form of extortion that is scandalous, that people have to go. And, you know, I always said, we have this predisposition to put people on a surety and property. Whereas in the majority of cases, you don't need to do that. People, you could put them on reporting conditions, you could put them on things. Only in the very serious cases where there's a real risk that somebody is going to abscond, that you really need to put property as a sign. You can impose curfew conditions, you could do all sorts of things. And it works because I don't get the impression that people abscond that much. The most pressing problem is people don't take down the date on time, or they're irresponsible and they miss a date, and then you have to issue warrants for them. But the reality is people will turn up, and you know what? They'll turn up even more if the case could get done quickly and they could have some finality and know what is going on. I of course endorse much of what Mr. Israel Khan has said. The suggestion about the categorization as murder makes a lot of sense, but we have to understand something. 42% of the persons are on remand for murder charges. Not every murder is the same. Because of the nature of murder, it includes a situation where somebody acts in self-defense. It includes a situation where a sister fights with the brother over a plate of food, and it includes all the things to the killing of prison officers. But not every case is the same. Treating everybody and refusing bail to all of them across the board in a society and a system where it's taken 10 to 12 to 15 years to get a trial, we need to revisit the question of bail for murder. And I know it may sound controversial, but in Grenada, judges grant bail in murder. Okay? There are appropriate cases for no bail in murder, but equally there are appropriate cases for bail in murder. And what makes it even more appropriate is the fact that if you can't get a trial for 10, 12, 15 years, give them bail on the basis that it is appropriate to give bail in the circumstances. I'm not saying that in every case everyone will get bail, but I remember as a judge granting bail to a young girl in Grenada who was a schoolgirl who was charged with a knife in school, get into a fight with another young lady and stabbed her, and the person died in a school, right? But this girl, you know, because of the age and the circumstances, and because of the fact in Grenada it is the judge's discretion to grant bail, she was granted bail. And what happened? She got her passes, she's got on her life, and I expect that she'll be getting a trial very soon, you know? And you talk about the bail boy system, that is something that His Excellency Justice Carmona, Justice Lucky were involved in, but it was an experiment that was hugely successful. We were able to take persons, and the problem was this: if you're a judge and you are faced with a young person who is a first-time offender, even if it's a gun offense or something, and you realize that there may be reasons why people find themselves in trouble, bad company, etc., but you get them to go to school or to get training or under a probation officer, and that was the success about it, because every one of those persons had to be supervised, had to report to a probation officer, had to come back to the court once a month to say how they were going, and their parents had to come with them. And it worked, and we put them under curfew. And they couldn't leave the house after 8 o'clock and between 8 and 5 o'clock. And you regulated, and you got the parents to parent. And we saw an amazing trial. Because the truth was this: we had to face the reality as judges that they were not going to get a trial for 10, 11, 12 years. And if I left them locked up inside there, what was the possibilities for those young persons? And that was something. And the thing is, we have innovative thinkers in our system, in the police, in the prisons, in the judiciary. We just need the support. The question of bail, much has been said. I do not take the view that the answer and the solution to all our problems of crime is increasing and increasing and increasing sentences. Okay? I think the answer is figuring out more innovative sentences. And I want to make this observation. In Trinidad, we have had plea bargaining legislation since 1997. We have had we've had suspended sentences, we've had community service orders, we've had all these things since 1997 going back. But they're simply not used. Very few people use them. And so I want to, sound a warning. It's nice to innovate and to put all these things, but we need to get people to buy in. With the plea bargaining legislation in 1997, there were issues because the prosecutors were not consulted adequately and they had difficulties in the way it was drafted. With the community service orders, there's a schedule at the back of it which says essentially what type of offenses you can get community service for. I think we need to revisit that schedule and widen it, okay? Because my experience is that if people think that they can plead guilty, get out of that system, but they will get something fair and not have the fear of 10, 15, 20, 25 years. I mean, in some cases, it is appropriate, and they will know. But in many cases, what we've been doing is we keep saying, we increasing the sentence, we increasing the sentence. And so it's not solving the crime problem. It's not deterring anybody from committing crime. So what is the value of that? Let us be more innovative and allow people ways to sentence so that people can meaningfully take into account their situation. The last 2 points I really want to make. We've talked about abolition. We've talked about sentencing option, plea bargaining. This is something that's very close to my heart, and it's been bothering me. There was a time in Trinidad where judges never used to take into account the time spent on remand in imposing sentences. We should have been doing it, and it was just a practice for years that it should have been done, but case law told us that we're supposed to be doing that, and we started. But it's creating a little bit of a lacuna in my view, a gaping hole, in fact. A prisoner who is on remand, once he behaves well, would normally be entitled to remission. And that is normally 8 months out of a year, Commissioner? Convicted, yes. Convicted. Now, it seems to me that if we are entitled to take into account the fact the length of someone has been on remand, and if that prisoner has been of good behavior, because I recently did a sentencing for someone who had spent the equivalent of 17 prison years, about 11 to 12 calendar years, somewhere close to 17 years. And the gentleman had been charged for murder. He was charged with his brother and father. And it was a fight in a village where he had gotten into an argument with someone before. He went home. The people came to his home and provoked a set of circumstances which led to a brawl outside his house. His brother and father got involved in it. And in the course of that, one of the persons was killed, stabbed. And he had a trial. He was convicted of murder, but his brother and father was found not guilty. But it took about 10 years for that trial to take place. Now, by that time, his brother and father not charged. He was prepared and willing to plead guilty to the murder, but he had been convicted. So we went to the appeal court. We won in the appeal court. The matter was sent back. And I wrote to the DPP, and the DPP immediately agreed and said, I will consider manslaughter if he's willing to plead guilty. And the gentleman was willing to plead guilty. So we did something called a Goodyear hearing, just so that the court could give an indication to him what is the maximum sentence the court. So he could make a decision. Do I want to plead guilty, or do I want to take my sentence at trial? The judge, in imposing the sentence, took into account the time on remand. But, you know, this was a person who would have, if convicted, he would have been, you know, he would have had the equivalent of 17 years, prison years. And there's no provision in the law that really allows for judges to take into account the good behavior of a prisoner while in custody. And I feel there has to be some formula that would allow, if a prisoner doesn't give any problem and he spends a considerable time, that remission entitlement should be factored in for the judges to take into account. Because I figure there's a lot of people who are there for many, many years and would be inclined to adopt a certain course if they knew that if they pleaded, that length of time would be equated and not just calendar years. Because everybody else will get the equivalent of remission because the prisons will calculate it in that way. They will calculate it in accordance with that. But if the judge runs the sentence from the date of conviction, you could lose out on that benefit. So it's something I think needs to be looked at because there's a need for reform. Finally, ladies and gentlemen, Honorable Attorney General, I have one last recommendation. I haven't heard it this evening, and I'm hoping it will find favor with you. The problem with the criminal justice system is that it is such a dynamic, complicated process. We have so many institutional stakeholders who have to come together to deal with daily running of the criminal justice system. We need to have a vehicle that is made up of stakeholders that is able to monitor how things are working. There are problems that arise on a daily basis, whether it be that prisoners are coming late in transport for whatever reason, or people in a particular district are having bail granted, but it is taking 7 to 9 days to process. And this is something that I'm very upset about because in Trinidad, once a judge grants bail or a magistrate grants bail, you expect that the family will be able, once they come with the documents, to get the person out and home in the same day. Now, I could understand that, you know, there may be occasions, but you have to call around to the different magistrate courts to find out whether the bailer ever take bail, etc., and that's the problem. But in the last 6 to 9 months, I have had 4 clients of mine who have been granted bail, and the papers have been given to the clerk of the peace in 3 magisterial districts, and in one case, to the registrar of the High Court. And it took between 5 to 7 days for that bail to be processed. What is the point in granting bail? And then to find out that the administrative aspect of it is falling down, that the person is still kept in custody 6 and 7 and 8 days, and in one case, 14 days, which was a young man, okay, who was charged. And the reasons that are being put forward, the sewer system in the court wasn't working, so the clerk of the peace was transferring, they call in the magistrate courts, and nobody answering, so they can't do the checks. And those are the kind of excuses that we are getting. That is a reality on the ground. That is what people are dealing with. When magistrates are not turning up on time in courts, or prisoners are not being brought for whatever reason because a habeas wasn't sent. There are so many cases where you have prisoners who are charged for one offense and they have other offenses, but nobody bring them to court because one is murder and they ignore all the other charges. We need to have a vehicle that practitioners, stakeholders can go to and say, we're having this problem. I'm not talking about judicial issues in terms of whether a judge do this right or do it. Administrative. Some mechanism that you can monitor, that you can go to, and so that you could bring the problem, and that vehicle is going to be staffed with representatives from all the key stakeholders who would have the authority to say, yes, we could solve this. We need to have something that is proactive, that is going to be driven, that is going to help us solve problems. We can't really, with the greatest respect, leave it for legislation to come in. We need some sort of monitoring mechanism. So at the end of the day, ladies and gentlemen, members of the panel, Attorney General, this is not an easy task. All of us have come here and done what everyone has done for the last 70-something years. We're talking. And, you know, no one more than myself would want to see some sort of change because there's a human aspect of it. And whether that is a prisoner, if that prisoner is guilty, then let him serve his sentence, let him do his time. But do not keep that person there for 10, 11, 12 years, 14 years in abeyance to be told, well, now go serve your sentence. Or worse yet, you are free to go home because it is too late at that point. And I have said this before, and I'm going to do like Mr. Khan. It's something that I want to say, but maybe I shouldn't, but I think today I will say it. When I was a young practitioner, someone who I respected and was a senior practitioner made an observation to me. This was around 1997, 96. The level of violence in Trinidad was not as it is today. People will come and rob you. They might hold up a gun, but they would use it to scare you. There was not that level of barbarism, that vicious, violent thing. Something changed. Something changed. And I am sorry, but it does seem to me that a lot of it may have to do with the way we treat human beings. And if we cannot learn to treat our prisoners with dignity, that does not mean they cannot be punished. They will be punished if they are guilty. But the greatest level of disrespect is to lock up someone on an allegation, ignore their family, ignore everybody else, and all the effects of what that has on the society. And we just leave them, and we just get so desensitized, and we don't care no more. It's like murder in this country. We so used to it on the front page of the papers. It don't matter. There was a time when I always knew I could tell each murder and who was charged, etc. I can't do that anymore because it's so commonplace. Please don't let our criminal justice system come to a point where we have lost touch with the humanity of it. Thank you very much.
Ladies and gentlemen, another very powerful and insightful presentation. Thank you very much, Mr. Persad, for that excellent contribution. I'd just like to say that perhaps it was good that I teed off, because a lot of the platforms in the slide presentation that I put forward are springboards for a number of the concerns raised there. It's not easy vaulting into a position where you have to manage everything and be responsible for everything. But it's a privilege nonetheless. And it's very rare that one gets the opportunity to discharge that responsibility and to hope to want to leave something better than the way you found it. My genuine desire as Attorney General is to leave a mark, which is a very simple one: institutional strengthening, which survives political cycles. I came into the office of the Attorney General, and I still have the same staff that I walked in the door and met. The reason is political appointments ought not to affect institutional runnings. And I thought that the only way that that could really make a meaningful impact was to practice what you would like to preach. But I understand that that's not a very common thing in our society. And one of the main reasons for this sort of forum is to begin to encourage the intellectualization based on data. The fact is that today, Rajiv, you'd be pleased to know, I looked at the Criminal Procedure Act, Chapter 1202. The word jail is still spelled G-A-O-L. And you're still to be incarcerated, be it under another piece of law or that. You're supposed to be incarcerated, there to be kept safely until due process has been served. But the issue of safety is obviously a huge factor. The impact I wish to put onto the table of how we manage systems, I'll tell you that we have done in the AG's office, I understand for the first time, a sit and rise analysis of the judiciary. Not my place, but it's a factor which I wanted to understand from a statistical point of view, so that I could track with certainty in my discussions with the Chief Justice how many hours we're sitting and what we're doing while we sit. The capacity constraint in the court is not so much of an issue. We in the executive have looked further into what other court potentials exist. And in many buildings, you would remember in the Dolce trials, where the trials occurred, at Chagaramas. You remember a number of places. We've mapped that matrix out as an executive already. The Chief Justice is actively considering the issue of improving the complement for analysis of judges that are required, and we're actively paying attention to the criminal justice articulation factors, be it in forensics, be it in paper management. We've even gone so far as to factor what outsourcing stenography is going to cost to simply manage the paper. The good news for Trinidad and Tobago is that I have a whole lot of jobs available. And when I hear people talk about unemployment, it's quite interesting, because you would have heard today, as a public, that you have a lot of vacancies everywhere. In the judiciary, in the prison service, in the DPP, in the Attorney General's office, in a number of places, in the police service, in the prison service. There are a lot of vacancies. There are a lot of very lucrative positions available too. As a practitioner in the civil law, I can tell you that to speed up civil trials, that I have used court stenography, not from the court officers or others, but I've had to pay, clients have had to pay for palantypists or court stenographers or CAT reporters, as you call them. And I can tell you that some CAT reporters earn up to a good $125,000 a month for CAT reporting, just transcribing what is said onto paper from an audio recording, believe it or not. So there are very, very lucrative opportunities available, and there's a lot of training available. I'm just throwing out a few bits for thought for people who may hear this after or who have heard it now. We have disaggregated the remand population by typologies and positions. We've put some of it into the public domain, and the specific intention is to operationalize the clearing of that system one way or the other. I'd like to tell you that there are a few things that you've mentioned today that I'm very grateful for, that I had not put on forefront burner, and certainly the issue of how we manage the information tracking. I can tell you that I'm aware that the Chief Justice has signed a memorandum of understanding with the government of Nigeria, and that a case management and monitoring management system is being procured. But the very good news is the reason why we're driving the Children and Family Court bill that we've tabled in Parliament, which amends 18 pieces of law, was to put into an organizational structure in legislation a monitoring unit on the children's end, and that finds itself for easy replication in other areas. The reason why this government has committed to giving the judiciary financial autonomy wasn't by mistake. It was so that the judiciary can spend on what the judiciary wants to spend on without executive interference or involvement. And that was a very serious and important decision to take for the first time in the history of this country. I'd like to say that the attenuation, which I believe is to be found in the criminal procedure legislation, for factoring time served in remand, is a very interesting and important observation. I thank you for bringing it to the fore, as is also the position of factoring the issue of bail, even if for murder. Now, I'd like to say, as the enabler of laws, the person with titular responsibility for laws, I am bound by having an obligation whilst having personal views. I'm required to engage in a process that is open and transparent, But ladies and gentlemen, for heaven's sake, my very simple plea to all members of the panel and to all members of the public is that we just can't do this alone. And public agitation is the be-all and end-all. But for heaven's sake, sensible public agitation is required. And if we see reporting or agitation that doesn't make sense, somebody has to have the courage to say so. I'd also like to say that it's very interesting now calling myself a politician, having been a professional my whole life, that it's very interesting to be constantly met by the expression when people meet you, you all need to do this, you all need to do that. It's always you all. And somehow that you all doesn't transfer into a positive, I'll pick up piece of the line and assist you. Receiving recommendations in writing, having the Law Association look at draft legislation that it produces, because they're private members' bills that can be piloted and championed. It's why you have that facility in law. It helps to make the load easier. I would just like, before opening the public floor, because this is a consultation. Yes, ma'am. Those of you who have joined us late and are saying yes, please as well, I'm just teasing. I'm thanking you for your patience. But I would just like to say, before we go too deep, we would very much like to welcome at this point some interaction from the crowd who has waited as long as you have. I would very much like, if you could please keep your positions as tight as you can. With your permission, I will now serve as a moderator and direct the questions appropriately. If you could just indicate by hand, and perhaps what you could do is to just line up at the microphones, not all at once so we don't have too many empty chairs. Perhaps we take it in threes. If we could have 3 persons at a time deliver sequentially, and then we can direct the questions to those who can best answer them. May I have 1, 2, and I'm looking for a 3rd person at the mic. I have 3. The 3 mics and 3 people present. We'll take them 1, 2, 3, and if you please, we'll then direct them to the appropriate people. Mr.